Welcome to Court Reacts. Today's case is a fiery courtroom clash featuring Mr. Christopher Lewis, who represents himself and pulls no punches in his bold accusations against the judge. From allegations of bias to demands for a written explanation of rulings, Mr. Lewis takes courtroom drama to the next level. Let's dive into this dramatic showdown.
I'm sorry for the delay, Mr. Christopher Lewis. Are you there?
Yes, how you doing?
I'm very good.
Sherika Harris, on behalf of Mr. Lewis, please state your name for the record.
I don't have an attorney. I'm representing myself. I articulated that at the last hearing.
Okay, I apologize.
Thank you.
All right, today is the date. Good morning, Mr. Lewis. Today is the date and time set for a arraignment on the bench warrant. I'm going to enter a not guilty plea on his behalf. I'm going to give him a $0 bond. Mr. Lewis, you said you were here last time. Why did you miss your date?
I actually didn't miss the date. I actually sent you a motion today to show you proof that I was actually in the hearing, and I was locked out of the hearing after an hour of waiting. As well as I sent you a motion for dismissal as well. I sent it last week. Yes, I sent it last week, but I resent it today, and I sent it in a Zoom chat as well to the prosecutor, the clerk, reporter, as well as the clerk.
I didn't get that motion, either of those motions.
Is there any way you have availability to look at the Zoom message, right? I sent it to not only your email, but the Zoom chat as well.
I need it in my email. I don't
sent it twice. I can tell you my email if you want to search it, but you should have it twice in your email. I resent it.
What's your email?
Okay, I'm resending it at the moment.
I'm gonna put my email address in the chat and I'll put my email so you'll have it. And send that to me, and I'll have an opportunity to read that. I'll confirm that I'll wait to confirm that you send it to me, and I'll give you a date. The next court date is going to be a pretrial date on May the 28th, 2024 at 8:30. You need to get a copy of that to the city attorney as well.
I'm actually just sending it to the prosecutor as well. Dia Mason, is that her?
Yes.
Prosecutor? Yes, I did just send her attachment. If she could send me a confirmation that she received it.
Get it to her email address. So Mrs. Mason, you put your email address in the chat as well, so Mr. Lewis can get you a copy of that.
I really appreciate that.
File of that motion, those motions that it has. All right. I'm going to wait on that. Once I confirm that you gave me that, I will recall the case. All right, let's pass that matter. Let's go back on the record with Mr. Christopher Lewis. I have received this motion, and I read the first couple of lines of it, and that I'm not concerned necessarily about the March 18th incident. I don't know what happened on that day, but you are here now, so we'll move forward.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case if you get the chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
All right, I'm gonna deny the motion. I will set the matter for.
Is there any way I can get a written? Can I get a written articulation as to why you're denying the motion?
I'm denying the motion because
I would just appreciate a written excuse. Can I get a written articulation?
I might give it to you in writing. I will.
Are we on record? Are we on record?
We're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Yes.
Okay. You were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking for a change of venue. I'm denying that.
I'm saying that I know there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
Okay, I'm denying a motion to dismiss. Okay, I'll set a trial date for you so you can be heard on that type of forum.
I insist that the court give me a written excuse as to why you're denying my motion, so I could take that to the tenor. Okay.
Well, you can insist all you want to.
Okay, I appreciate that, but I'm telling you, you're telling me today why you're not going to look into it or give me a hearing, that's so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that, so I'm just asking that you can give me a written excuse that I could go take and complain against you on. Because
here's what's happening. Mr. Lewis, who has chosen to represent himself, begins by accusing the court of locking him out of a previous hearing and violating his rights. Things escalate as he repeatedly challenges the judge's authority, claiming due process violations and demanding a written explanation for the denial of his motion. At one point, Mr. Lewis questions the judge's legitimacy under the Commerce Clause and insists on a change of venue, stating he wants his case heard by a real judge. The judge, maintaining composure, denies the motion for dismissal, but sets a jury trial date, giving Mr. Lewis the opportunity to argue his case before a jury. Despite the judge's efforts to maintain order, Mr. Lewis continues his fiery objections, asserting that the entire process is a violation of his rights.
Excuse that I could go take and complain against you on, because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there. Overwhelming. So at the end of the day, like I said, there's no crime. This is a fraudulent charge. There's no suspect. Y'all suspect me for no crime. There's no victim, no losses. Okay? And in a minute, it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm going to go to the tenor without it and let them know that you refuse to give me a written excuse and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. Because you're Article 1 judge under the Commerce Clause. This conflict of interest, you only here to make money, man. You know what I'm saying? It ain't no crime.
Ain't
no victim or no loss, bro.
Listen, I'm not your man.
Look, sir. Hey, sir, respectfully, you're Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to somebody. I'm asking you to give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence or change venue. Because if not, I'm going straight to the tenor right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, that's all we need. I don't want to hear any more.
All right, cool. It's cool. I appreciate it. This due process this is a due process violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They're not prepared to present a case. I'm telling you. They're not prepared to present an injured party. So what are we doing?
Listen. Please do not say any more. You've already made your record. I've given you that opportunity. If you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You take whatever. Wait a minute. Let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date And at that jury trial date, you will have the opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue it that way, okay?
I appreciate that, but I was still like a written.
You order the transcript. You order the transcript. It's in the transcript. You asked me to read the couple of paragraphs that you made. Most of the paragraphs was referencing the incident on March 18th, as you and I'm not even debating or disputing it. I said I'm not concerned about March 18th or any missed date. I said that the most of what you're saying is in the it's not you know, I'm not even going to hold you to that, but in paragraph 2. Moreover, I want to emphasize that the initial charge against me in this court is fraudulent. I don't know that to be the case. That's why I'm giving you an opportunity to have a jury trial, and they can make the determination. Neither the complaining witness or the prosecution is prepared at any point of this case to present an injured party or any reported damages/losses. So it becomes abundantly clear that every proceeding taking place is strictly an attempt to seek funds where there is no crime and not seek real justice. So we are giving you real justice, because if you say that there's been no crime, then you have a right to a trial. And that's what I'm giving you. So I was assaulted, detained, and my property illegally searched and seized with no suspicion of crime at the hands of the complaining witness, Joshua Martin, and assisting officers. I do not consent to these fraudulent proceedings and demand that the court dismiss the charge immediately with the appropriate remedies. And I'm dismissing the motion based on that, because I am giving you a proper forum to argue your case, or allow me the right to change the proper venue of federal court where my U.S. constitutional rights will be upheld and not disregarded by Article 1 judge under the Commerce Clause. I don't understand that of the United States Constitution, indicating a clear conflict of interest. I do not wish to proceed with this matter. You don't have to proceed any further because I'm dismissing the case. He did cite some case law. It was at Sherrar v. Cullen, 481 Federal 2nd 945. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of the U.S. constitutional right. Louisville versus Motley, 211 U.S. 149, South 29 S period court. CT 42, any tribunal court finds absence of proof of jurisdiction over a person or subject matter, the case must be dismissed. The accuser bears the burden of proof beyond a reasonable doubt. All right, so I'm dismissing the motion. All right, so you want a trial date? Give me a jury trial date, please, Ms. Memphis. And you can get a copy of that record on of what we just made by going through the proper channels of the court to get the court reporter to produce that record.
I can't even get the court reporter to respond to my voice messages or you to respond to my emails, sir.
The court is not going to respond to your voice message. The court reporter is going to respond to you coming down. The 36th
district told me to call her today, that I was locked out of my trial date. I had a scheduled trial. The court told me to call her that day, and I called her that day, and she still hasn't responded. So I'm trying to see if the court that you work for is trying to tell me how the appropriate channels, and then y'all doing it different in y'all court. What am I to do?
I think you're talking about the court clerk and not the court reporter. This is a distinct.
Yeah, I was told to call the clerk the day that I was locked out. The moment I was locked out.
We've moved past that. Getting locked out.
But that was my trial date.
Yeah, so I'm giving you
How soon can I get another trial date, sir? How soon can I get another trial date? That's what I'm asking.
That's what we're trying to do now.
I'm getting a jury trial.
A jury trial. I'm not gonna. I'm gonna let the jury of his peers hear what he has to say.
It look like it's going to be July the 23rd.
Before you say that again, Ms. Mathis, just verify it before you say it. Please, the dates.
Okay, I'm just checking.
I know, but you're thinking out loud.
Okay, I'm sorry.
Good day.
Yes.
July 23rd, 2024 at 9 a.m.
July 23rd.
Yeah, 2024 at 9 a.m. We'll have a final pretrial the day before.
Why would we need a final pretrial? Why would we need a final pretrial?
Because I said I wanted one.
But that's how you
all
protecting
parties-
your interest. You protecting your interest, and you're gonna dismiss it on that date. So you trying to play with me? You could dismiss it
Oh my
today, sir.
God.
You literally,
A final pretrial 8:30.
Miss-
You are
Miss
literally
Mason.
violating my due process. You can't even give me a written excuse, but you're gonna all this whole.
Mr. Lewis, I know you don't want counsel, but is it
He
possible
needs
we
it
could talk in a
bad.
breakout?
He doesn't have
Hey,
a clue
excuse me,
what he's
ma'am.
talking
I do.
about.
Excuse me, ma'am. I am in
Go
pro
to
se.
Go to
I'm in
judicial
pro se.
tenure. Go wherever you want to. Final pretrial
I
July
am. It's all good.
22nd. And the
I am.
trial date is going to be July 23rd. All the parties must appear on the final pretrial date, and the jury, and that can be on Zoom. And the next day, the jury trial date is in person. Have a very good day, Mr. Green. Best of luck to you.
That's not my name.
I don't know, Mr. Lewis. I'm sorry. Have a very good day. Best of luck to you. All right.
And that's how Mr. Lewis turned a standard hearing into a courtroom spectacle. What's your take on this? Was Mr. Lewis justified in his outrage, or did he cross the line with his accusations? Let us know in the comments, and don't forget to subscribe to Court Reacts for more intense courtroom moments. See you next time.